Welcome on behalf of Trust and Estates Magazine. My name's Marty Shenkman, and I'm joined by Barry Flagg. I'm going to get it right. Inventor, founder, and president of Veralytic.
Correct.
And you're an insurance guru.
Some say, yeah.
Okay. Let's talk about a topic that is interesting on a lot of levels and maybe a game changer. I understand that New York and New York is often sort of leading the pack on regulations. New York has a best interest rule for life insurance.
Correct.
Salespeople, consultants.
Correct.
Why don't you explain what it is, and then let's talk about how it may transform what insurance experts, consultants, salespeople have to do.
Sure.
And let's make a point of discussing what it means to everyone else in the estate planning world.
Cool, sure.
Okay,
Sure.
so what did New York do, and when?
So in August of last year, August 2018, the New York Department of Financial Services issued what they're calling a best interest rule for life insurance and annuities. It's Regulation 187, and it defines agents and brokers as life insurance producers and imposes on them a duty, a fiduciary-like duty, to serve the client's best interest, and defines what that is, which is very consistent with other fiduciary duties for trustees, the duty to examine costs, the duty to set reasonable performance expectations, the duty to understand the risk involved in certain things. That's generally
When you say set performance expectations, is that going to change what we see in projections for insurance policies in any way?
Potentially. It's new. So the carriers have not yet really figured out
What they're going to do.
The insurance companies have not figured out how they're going to respond to this. They're asking questions, but the National Association of Insurance Commissioners, the lawyers representing the National Association of Insurance Commissioners, requested that the New York Department of Financial Services include in the reg the ability for producers to continue to use illustrations as due diligence tools. And that request was denied. So the use of illustrations, I think, is going to change, and the illustrations themselves may change in order to project or at least connect these projections to actual historical performance, which in some cases, you and I have talked about before, they just don't.
Yes. Issue. When does this become effective? I don't think we told the audience.
February of 2020.
And what might people in the insurance industry want to do to prepare? And what might lawyers, accountants, wealth advisors, trust officers that refer clients to insurance consultants, what are we going to have to do as well?
So what life insurance professionals are going to have to do differently is going to be determined by the insurance companies. They need to develop policies and procedures, forms, and some oversight for their producers.
So they're going to be training everyone on what to do because of this.
Correct. I'm actually working.
Do you think some companies may just get out of the New York market, or are they viewing this as a trend that's going to affect everywhere that they just have to deal with?
That's happened before, where New York, being something of the trendsetter or the bellwether for life insurance regulation, or for regulation in general, financial services regulation in general, they were the first to come out with the cybersecurity regs, and virtually every state just adopted it. So they're definitely a bellwether. They're also among the more stringent in protecting consumers. And so that has had some carriers not want to comply with those regs and leave the New York market. I do know California made a written request to the National Association of Insurance Commissioners, who creates model regs, to expand the current annuity suitability rule to include life insurance and to address some of the things that New York is addressing. In the recent meeting of the National Association of Insurance Commissioners, which was, I believe, third quarter last year, they denied that request, and California inferred in their letter that if you don't do it nationally, we're going to do it. And I've also spoken to the director in Florida, and they're interested in this. So I think
Was there some event or any specific issues that precipitated this in New York?
Yes and no. I think the catalytic event, or at least this is the speculation, kind of the political speculation. The catalytic event was the DOL rule, which was promulgated under a Democratic administration, was vacated by the Fifth Circuit in Texas, kind of a Republican-leaning court, if you will. And so the governors in Democratic states are concerned about consumer protection in the financial services area. So I think that that's some of the catalyst. There's also what I call this relentless march toward clients' best interest. It is, you got the DOL rule, yes, it was vacated. The DOL has I don't know if they formally announced, but the media is reporting that there is another DOL rule coming that is either going to be harmonized with the SEC best interest rule, or they may just issue one between the two. States like Nevada, Nevada has passed a fiduciary rule for financial services, not specific to life insurance, where New York is actually specific to life insurance. New Jersey's considering one. I believe Maryland is considering one. Connecticut's considering one. So to me, this is a relentless march toward clients' best interest. And I think New York just picked up the mantle and decided to do it, again, because they have this reputation for being the standard setter for the insurance industry.
So as an estate planner, an attorney, an accountant, a wealth advisor, a trust officer, everybody recommends insurance people to clients because there's so many needs. With just apropos to the current environment, there's going to be a lot of clients perhaps before the 2020 election, or if there is a Democratic wave, blue wave continuing after that election, that are going to try to move to use their temporary exemptions because who knows where that's going. And a very common planning tool is non-reciprocal slats and using insurance to backstop it. So if there's this big step towards insurance in this new application, do we need to consider anything in who we're recommending? In other words, should we find out whether clients, insurance consultants are adhering to this rule? How do we deal with it? Do we deal with it?
I do think it
And if it's only in New York, even if we're in another state, isn't that sort of the gold standard we're going to want for people we refer to? But what do we do if it's not law elsewhere?
I do think that there's an ethical dilemma here, a potential ethical dilemma, that New York has issued a rule that says you need to do, as a life insurance producer, you need to do things that that are common fiduciaries. For instance, a fiduciary has a duty to exercise reasonable care, skill, and caution. Language like that is in the New York reg. One of the reasons why I think the New York Department did not, in the reg, permit the use of illustrations is FINRA, the chief regulatory body of financial services industry, says that comparing illustrations is misleading. The Society of Actuaries published a study years ago, which has been just not paid a whole lot of attention to, saying that comparing illustrations is not just inappropriate, but fundamentally inappropriate.
Wow.
And the OCC, the chief regulatory body of more fiduciaries than anybody, updated their handbook for unique and hard-to-value assets. And in that book, they say that comparing illustrations are unreliable, or illustrations are unreliable and not very good for comparison, right? So as a fiduciary who has a duty to exercise reasonable care, skill, and caution, I think it's going to draw attention to, well, maybe we shouldn't be relying on things that financial insurance and banking industry authorities say are misleading, fundamentally inappropriate, and unreliable, right? So I think it's going to change the behavior of not just people in New York, but planners working with insurance professionals in New York. I mean, and the industry is fighting this. The National Association of Insurance Commissioners was one of the parties against the DOL rule, who prevailed.
But the New York is already enacted. I mean, it's going to be law. You don't think they can derail it at this point?
Well, the DOL rule was law, and they had it vacated.
But so you're not sure New York's going to really become effective? It's another year before it becomes effective.
Could be. Well, no. Yeah, it's another year before it becomes effective. But then there is a cloud. So if the National Association of Insurance and Financial Advisors, NAIFA, if they were successful in literally undoing a law that was on the books, there is a question as to whether or not the New York reg will survive.
Interesting.
the New York reg is written differently very differently in a variety of ways than the DOL rule. So I don't think they can use the same argument that they used to vacate the DOL rule. But there are several parties, several large producer groups in New York who have filed lawsuits to undo the rule.
Wow.
Which I think brings back this ethical dilemma, right? So if this reg is consistent with other fiduciary rules, right? It's not exactly the same. It's kind of like if you'd asked me to write a rule in French. I'm not very fluent in French. So the insurance industry is not very fluent in fiduciary, so it's not really well written, but it's got a lot of similarities between ERISA, the Uniform Prudent Investor Act. And so if this rule has been issued, and it's very similar to, for instance, lawyer's standard of care, or a CPA standard of care, or a trustee's standard of care. If it's there, and the industry's fighting against it, I think that there's a question. If I was an attorney, I'm an attorney, and my client's best interests are at the center of my work.
Right.
I now know that there is some segment of the industry that's fighting against the standard of care that I live by.
Right. So what do you do?
You got to ask some more questions. Certainly, to me, the big three things that an attorney or a CPA or a trust officer can do just to ascertain whether or not they're working with someone with a fiduciary orientation or not. First and foremost, if somebody brings you a comparison of hypothetical illustrations, that financial, insurance, and banking industry authorities say are misleading fundamentally, right? So that's a red flag.
Right.
However, on the other hand, if they're showing you costs instead of hypothetical projections based on some assumed rate of return, if they're showing you actual costs and they're showing you the historical performance, not that historical performance is any guarantee of future results, but it's an accepted means of setting the reasonableness of performance expectations. If you're getting that as an attorney, a CPA, or a trust officer, then I think you have a much better probability. I think you resolve the ethical dilemma because it's not a regulation that has jurisdiction over CPAs, attorneys, or trust officers.
Right, but if there's a gold standard, you want to
exactly.
You want your clients to have that. Any last words so we can wrap up?
It's been a long week here at Heckerling.
All right. I want to thank Barry Flagg for joining me. Please bear in mind that the video clips are for educational purposes only, and we have not rendered any tax, legal, or insurance advice. Thank you.
Thank you.